Well, I don't remember. I don't know what I did. I can only tell you that based upon the original numbers that I'm provided that I think I did, because it looks like I did it. You can tell in how these other things are written. That's how I would have written them. That's what I do. This is my practice. To understand now, because I didn't compare them before, because I wait until all the arguments to go over all of the things, is the point that Mr. Stroud is making, that on this very important, serious list, is not identified with a date. But the updated total is dated March 19th, 2024 of this very serious list. Waiting for the district attorney. I don't know what he's doing, but he's running a little bit late. So what I'm going to do is I'm just going to send the court into the waiting room until I have Mr. Schmidt, and then when I come back, you'll know, and we'll be ready to go. Thank you.
Probably my fault he's late. I was just in there talking to him. So.
And good morning, Miss Kathy Molsom. Thank you so much for filling in today. I really super appreciate it.
Good morning. You're welcome.
I guess he's here now, and that's okay.
I apologize for being late. I had to use the bathroom.
Our deputy court security officer blamed your lateness on him. So.
Well, I think we were done before 9, but maybe I remember wrong.
I don't know. Anywho, we're all ready to go. And I got a state's argument. Unless I missed something, Mr. Stroud, I didn't see that you filed anything else. Are you simply just going to rely on your oral argument today?
Yes.
That's perfectly just fine. I just wanted to make sure I did not miss anything. We will go on the record in the matter 25 CF41, State of Wisconsin versus Heather Honeycutt. The state appears through District Attorney Kevin Schmidt in person. Ms. Honeycutt appears by video conferencing from Techeetah Women's Correctional Facility. We have Tripp Stroud, her defense counsel, also by video. We're set today in this matter for the restitution argument portion. We went through and were able to complete the hearing and all evidence as it related to the restitution. However, we ran out of time and therefore needed to set a second argument portion. Ms. Honeycutt wished at the last hearing to be transported to Techeetah Women's Correctional Facility and not stay in Burnett County Jail. And she wished to appear by video conferencing at this hearing. Is that correct, Ms. Honeycutt?
Yes, Your Honor.
If at any time you have any questions or concerns and you need to speak with your attorney, let me know and I can send you into a confidential breakout session, okay?
Okay.
All right. Mr. Schmidt, I did receive your argument on the restitution matter. I've reviewed it. I've made notes. However, for the record, please present to the court what you would like me to consider.
Oh, if you recall at the last hearing, I want to do my argument in writing and Attorney Stroud wanted to do it verbally.
I did, but I was just asking politely if you wanted to say anything on the record.
Nothing additional other than my written argument.
Okay. Mr. Stroud, I'm going to presume you read it. I believe it came through yesterday afternoon, but I can't recall. No, it came on July 10th. You have the floor.
Thank you, Judge. You may recall during the sentencing hearing, I said that this case really should have been tried, and I think that the restitution hearing shows why. The state has the burden of proof by the preponderance of evidence to establish the amount of restitution and the basis for the restitution. And the evidence after almost 4 hours of testimony was a complete quagmire. This is Exhibit 4 Judge, I'm holding Exhibit 4. I'm going to reference Exhibit 4.
I have it here.
Remember, this exhibit came in during I don't know if you want to call it rebuttal, but Mr. Fry was recalled at the end of the hearing. Do you remember that?
I do.
He was motioning in the back. He said, oh, and you said he probably has the list of property that he made in the valuation that Mr. Otto prepared back in 2016 or 2024. And sure enough, it was the list. That's Exhibit 4. This is the list of property that Mr. Fry claimed had been taken. This was the list that he brought to Mr. Otto to value. Mr. Otto dated it March 19th, 2024, and then signed it on the second page. And the total value of property that was submitted to Mr. Otto and that he put his signature to was $44,350.21. Now, what is missing from Exhibit 4?
Are you asking me?
Rhetorically, I'll answer the question. There's no list. There's no silver maple leaf coins on Exhibit 4. There's no gold South African pirate coins on here. None of that. Where does that appear? In Exhibit 2. In Exhibit 2, magically in March of 2024, Mr. Otto says these are the coins. It's at the top of the list. Property that the state is claiming is worth, the gold Krugerrand coins collectively are worth $101,000. The gold Canadian maple leaf coins they're saying are worth almost $56,000. But here we have in Exhibit 4 the list that was actually prepared at the time that this theft was discovered. Mr. Otto's own handwritten notes contemporaneous with that list. Those coins are not on this list. Why would Exhibit 2 include those items? Because the prosecution prepared this list, not Mr. Otto. Mr. Otto testified he doesn't even have his notes from when he first looked at the property in 2016. He couldn't remember exactly what he did in 2024. Luckily, Mr. Fry had the actual copy in Exhibit 4 of what he provided to Mr. Otto, and that shows those coins weren't even on there. Picture, Judge, that you are advising a client. Picture your private practice days, and a client has retained you to advise them on the purchase of a business. They're doing their due diligence to buy a business. And you're given a document that looks very similar to Exhibit 2, and it's got a list of the business for sale. It's got a list of the assets from 2016, 2024, 2025, 2026. Looks like a lot of valuable property on that balance sheet. But because you want to do a careful job for your client, you want to actually talk to the expert that prepared that balance sheet. And what you come to find out is pretty alarming. You find out that actually that expert who you're interviewing, the company's accountant, didn't prepare this balance sheet. The company's lawyers did. You also come to find out when you're asking, okay, so where did you come up with the value for the property that you have on this list? The expert says, well, I looked it up on the internet. I looked it up on eBay. What is selling for on eBay? And then you come to find out that on this balance sheet, there's actually been items added to the list of property that weren't in the original list. you go back and look at, okay, well, let's prove to me that you that the company's assets in 2024 included these, two most expensive items on most valuable items on here, and you get the actual list, and it's not even on there. And then you talk to the expert even more, and you find out that the expert is not licensed to value this property. The accountant is not licensed to value the property that this company is trying to sell your client. The expert admits they're not qualified to even give an opinion on some of these things. Now, your advice to that client would be to run for the hills because something fishy is going on with this business. Something fishy, someone is trying to sell you a bill of goods. The reason why it doesn't sit right with anybody and why it was so shocking that the final number submitted to the court for restitution almost quadrupled from what was proposed, what was set forth in 2024 is because there's something abnormal, something that's not right here. We've got a list of property that was prepared by the prosecution and given to the expert weeks before the restitution hearing. The expert didn't prepare Exhibit 2. Mr. Otto didn't prepare Exhibit 2. He didn't check his notes. He didn't check Exhibit 2 against his notes to see if it was accurate. He didn't even have any notes. He didn't even know he had any notes until Mr. Fry produced Exhibit 4. And Exhibit 4 doesn't match Exhibit 2. In fact, Exhibit 4, which was made at the time of the theft, before anyone had pled guilty to anything, before there was even an arrest. Exhibit 4, to me, Judge, is the most reliable piece of evidence, the most important piece of evidence that was presented at the restitution hearing. After almost 4 hours, we didn't get the actual truth until the very end of the hearing, which is that the value of the property that Mr. Fry believed was stolen amounted to $44,350.21. And that list of property did not include the gold Krugerrand coins or gold Canadian maple leaf coins. The addition of those items in a list of property prepared by the state that the state's own expert didn't even review or compare to his original notes, that doesn't line up with the original notes, should be completely disregarded as unreliable and objectively unreliable evidence. So, Judge, the number that I would propose, the number that I think is supported by the truth, is $36,626.60. And that's crediting Mr. Otto's valuation from June 9th, 2026 for everything except the gold Krugerrand coins and the Canadian maple leaf coins. And that's me giving Mr. Otto credit for his reputation as a outstanding businessman of high integrity and honesty in the community. That he looked at these items and gave it his best shot based on his experience to value those items. And if we look at total all those up, it comes out to $59,343.60. And then we turn to Exhibit 1, which is the value of items that were recovered by Mr. Fry. The total amount there is $22,717. Subtract that from the $59,343.60, and you get $36,626.60. That's,
Can you repeat the number? Because you said 59,000 and in my calculations, if I'm just listening to your argument, I only get 53,812. What was your calculation?
so I took I'm looking at exhibit 2. I took Mr. Otto's grand total amount. It's right in the middle of page 2 of exhibit 2. And if I'm reading his handwriting correctly, it looks like the grand total was $217,012.60.
Correct.
And then I subtracted.
Oh, I'm sorry. I used the wrong numbers because it's such a interesting exhibit. I used the March 2026, not the updated. There's where I went wrong. I now see the difference. Thank you. Sorry, I did not mean to interrupt your argument.
No, that's fine. And I'll just finish, just for the record, I'll just finish that calculation. So I took the $217,012.60. I subtracted the $101,728 for the gold Krugerrand coins and the $55,950.40 for this gold Canadian maple leaves. And I did that correctly. Then the math comes out to $59,343.60.
Okay.
On to the second piece, which is Ms. Honeycutt's ability to pay. I read the state's brief. I understand, the thing that jumped out to me was there's no reason why Ms. Honeycutt could not work more than one job. I think, Judge, I think it's a tough position to be in because you want to make sure that there's repayment and that the goals of restitution are met. And then at the same time, you also want to balance that this is a human being who's got to live and pay for a roof, eventually is going to have to survive on her own and stand on her own when she comes out of prison. And that she's got to put a roof over her head. She's got to put food on the table. She's got to be able to put gas in the car. And live a life. And I think the proposal that we should take into account in the ability to repay analysis that an assumption that someone would work 2 jobs is asking an extraordinary amount from somebody to pay off a debt and to factor into their ability to pay. Why not? Why stop at 2? Why not stop at 3? You should have 4 jobs.
Well, I'm going to say I see multiple people with 4 jobs or, well, at least 3 jobs trying to make ends meet and have a life. So that's a bad argument.
I understand that point. I think that having a full-time, having multiple jobs add up to full-time is not an unreasonable ask. I think full-time in Wisconsin is defined as 30 hours. I don't think that's an unreasonable ask at all. And I agree. There are many people out there that stitch together multiple employers to add up to that many hours. But asking someone to work 50, 60 hours a week and make a payment plan or impose an obligation on them on the assumption that they're going to be working more than full-time, I think is not a fair ask to make of anybody.
Well, the world is making that ask on a whole lot of people right now, Mr. Stroud, a whole lot of people who don't have to pay back restitution for criminal actions just so they can survive. So again, I think that's a terrible, it's not winning me over with that
All right.
argument.
The other aspect to consider, Judge, and I don't think Miss Honeycutt is Miss Honeycutt is coming up from a place where she has a high school degree. She has what I would describe as a spotty work history. And after she is released from Techita, she will have a significant gap in her employment, a gap which is filled by a felony conviction for theft. And I think the quality of work that Miss Honeycutt, that we can reasonably assume Miss Honeycutt will be eligible for, is gonna be pretty low. It's gonna be pretty low. And so I also think that should be, regardless of how many hours we're expecting Miss Honeycutt to work, she's not going to be making very much money. These are going to be jobs where they are just looking for somebody to fill those roles. And so I asked the court to take that factor into consideration as well. She's going to have an enormous mountain to climb in terms of finding reliable employment. And the court should consider that as part of the ability to pay analysis. I'm not saying she shouldn't pay anything. What I'm saying is that there's a line at which we're asking an extraordinary, impossible amount for somebody in Miss Honeycutt's position to be able to pay back. So I think the amount that the court finds is due in restitution. I think we need to balance the realistic possibility, achievable possibility that she'll be able to pay things back and be able to take care of herself through work. And I'll pause there, Judge, if you have any questions.
I do not with your argument. Mr. Schmidt? Rebuttal?
So a restitution hearing is not the place where you get to challenge what you pled guilty to. Ms. Honeycutt pled guilty to theft of over $100,000. At the plea hearing, she stipulated to an amount of over
124,000 something.
To the extent that it appears today, she's trying to break her plea agreement. I think she's already stipulated to that amount. And I think that because of the way the restitution statute is written, that the court may order restitution related to any crime considered at sentencing with a nexus to it. I think arguing it should be less than 100,000 doesn't make any sense. I'd also note that Ms. Honeycutt makes a lot of allusion to Exhibit 4 somehow being a smoking gun or strange or something new. Exhibit 4 is literally in the criminal complaint. It's pages 5 and 6, and the criminal complaint also adds, he gave this list and then also said the Krugerrands. The Krugerrands are referenced on page 4. None of this is new or controversial. It's been information available to Mr. Stroud for over a year. His argument is effectively, you shouldn't believe Timothy Frey, the victim, that the Krugerrands existed and were there. That's what I'm kind of hearing. He's saying you should believe Exhibit 4, which is his claim of in a list of estate items that didn't include the Krugerrands.
I'm going to stop you right here with both of the things. To Mr. Stroud and Ms. Honeycutt's benefit, nobody was provided this very strong and very convincing Exhibit 4 to either Mr. Stroud or to Ms. Honeycutt during any process of this matter. But a strength of the state side and the victim side is, and it was stipulated to $124,631.47. So you can argue those things, but for the fact that Exhibit 4 was not provided to Mr. Stroud or Ms. Honeycutt during the whole process of this matter, things could have been different, because I am going to tell you, I do not see at all the gold Krugerrands or the Canadian maple leaves on the very important document signed by the very important expert, Mr. Otto.
Judge, that exhibit is in the complaint. We didn't transpose the language. It's literally a photocopy of Exhibit 4 is pages 5 and 6.
Okay, so let me go.
That's why I'm saying they did have that.
That's in the complaint?
Yes. And the complaint also relates, Mr. Frey gave that, and then he also said, I also lost the Krugerrands as well as the Taurus 9mm handgun. That's what's in the complaint. That's what she pled guilty to, with the theft of over $100,000.
It is in the complaint.
That's why I'm saying it wasn't some strange new missing smoking gun type exhibit.
Okay,
Uh,
better understand.
So I think that a lot of what Mr. Stroud argued had to do entirely with, Mr. Otto, what Mr. Otto knows. Restitution hearings are not, the trial. Restitution hearings are supposed to be something informal to accommodate the fact that it's supposed to be informal, to be more favorable for victims so that they, without their advanced knowledge and experience, can present a case. The state helps in these cases by helping organize and collect information and presenting it. What was presented is the exact stuff that he presented law enforcement back when this case happened, which is referenced in the criminal complaint. The value of it increased, specifically gold and silver, increased a great deal. Bob Otto testified to that. All the other stuff we did with testimony for Bob Otto was to just demonstrate his expertise and knowledge and how thorough he goes through things, and just that he is an expert. He's an expert by experience, and this is what he does. To the extent of the items taken, it was always predicated on Timothy Frey saying, these items existed, they were stolen from me. The reason I know these specific items were taken is I did an estate. I also knew about these Krugerrands. I think we've met the burden of preponderance of evidence. I think the stipulation to the initial amount, the 2014 amount itself, is itself an admission that these items at these values from 2014 were there, and that Bob Otto testified the value went up. And following the restitution statute, it's the value at sentencing minus what's been recovered in the meantime. I think that the values are very reasonable based on what Bob Otto said, and based upon how him and Timothy Frey explained, we asked these lower, bullion material cost values for assessing the value. And then we did the benefit for removing the things recovered, doing a higher collector's value. They were trying to do conservative estimates, and I think that the court should order that conservative estimate. As to ability to pay, Ms. Honeycutt has many years of work ahead of her. There's no reason she can't pay this. The restitution order is not supposed to be something where, it's supposed to be easy. It's part of the punishment. Thank you.
The issue that I'm having and I'm seeing, and I'm looking that Exhibit 4 was used as an attachment within that criminal complaint, and Exhibit 4 only goes to number 70, and then after number 70, then there's the 71 added. That's not on Exhibit 4. The gold maple leaves. 72 is the gold Krugerrands. 73 is farmland title paperwork, and then there's other additional items below. So you have Krugerrands in there twice and maple leaves twice.
My Exhibit 4 doesn't have 71 and 72.
Yours does, or whatever exhibit is. I don't have them marked. I just have the paper. Exhibit 2 is yours. Exhibit 4, I do have it marked. That Exhibit 4 is the one that doesn't contain those. Exhibit 2 does contain those, the one that you drafted or your office drafted. I'm just looking at the criminal complaint where your Exhibit 2 adds on numbers that were not in Exhibit 4 when Mr. Otto signed all of these, and that would be Maple Leaves, Kruger Ann's farm title work, and a handgun. And then I just said, and additionally, you can look in the gold Kruger Ann's and Maple Leaves were added twice in your criminal complaint. So
Exhibit 2 is what we actually relied upon. It's what Timothy Frey and Bob Otto testified to is the value as of the day of sentencing.
yes, I get that. I understand that. I get all that.
Mr.
just-
Frey testified, you know, when this first happened, he had to scramble to get numbers to the police. He did the best he could. Now, after having the benefit of a year to put things together to do the restitution claim, he put forward the complete restitution claim, minus items that he didn't have documentation for.
The thing that it's hard for me to understand now, because I didn't compare them before, because I wait until all of the arguments to go over all of the things, is the point that Mr. Stroud is making, that on this very important, serious list from it, the very serious list is not identified with a date, but the updated total is dated March 19th, 2024 of this very serious list of the things that were from the estate and were valued, which do not contain the Kruger Ann or the Maple Leaves. And the very important list is signed by Mr. Otto. And Mr. Otto's testimony very clearly said, well, I don't remember. I don't know what I did. I can only tell you that based upon the original numbers that I'm provided that I think I did, because it looks like I did it. You can tell in how these other things are written. That's how I would have written them. That's what I do. This is my practice. But in the list that he signed, it does not mention Kruger Ann's or Maple Leaves at all.
It comes down to whether you believe the victim or not. Timothy Frey testified that these things existed, they were in the safe, and they were stolen. If the court does not believe his testimony meets preponderance of the evidence, then that's exactly what the court should conclude. What Mr. Stroud says, that you should just not believe the victim.
If I could respond to that.
Yeah, I might have one more question.
Sure.
No, I don't. You can continue. You can speak, Mr. Stroud.
This is why a restitution hearing is an evidentiary hearing. We don't just fall back onto allegations in the complaint, is because even though it's not a criminal trial and the burden of proof is different, credibility needs to be tested. And the court heard from these two witnesses at length, and Mr. Fry said Exhibit 4 is what he prepared. His list, taken from the list he gave to Mr. Otto in 2016. That's the contemporaneous evidence before anyone was convicted of anything, before there were even any suspects.
But Mr. Stroud, isn't it correct? Because this is my memory and I have a pretty good one, that part of the deal was, and it was accepted, and I went over it multiple times, that there's a stipulation to an amount of $124,000, $124,631.47. That's correct, correct?
Yes, there was a stipulation. We took evidence, and I think the truth shows that there's a lower amount. There's a lower
But
amount.
you
of
can't go back
restitution.
on a stipulation that breaks the plea agreement, because that was the plea agreement, correct? So are we going to do all this all over again? Because I'm hearing that this is not correct. Because I took a plea and the state gave a plea based upon the fact that there was at least a minimum stipulation of $124,631.47. Either you're stipulating to that amount and no more, or I'm hearing that this didn't go as planned and that she's kind of trying to jump the plea.
No, there's a stipulation. There's a stipulation. I'm saying
Okay,
the truth.
That's all I need to know, that it's stipulated to $124,631.47 based upon all of the information that was at hand and provided during the discovery. And as stated in the criminal complaint, because in the criminal complaint, it does contain that Exhibit 4, and it does also contain in the complaint that addition of the Krugerrands as well as the Maple Leafs. I understand your argument and your point. I get where you're definitely coming from, Mr. Stroud. And it's a very persuasive argument as it relates to the value of the property and how the numbers were arrived at and actually agreed to in 2024 by Mr. Otto, who very clearly, I recall, stated, I don't really remember. I don't remember these one for one, what all they were. I remember I did it and I went over these things. And then in 2024, I have this list where I increased the values from 2018 to 2024 values. And then I dated and I signed it. Very persuasive argument, but for the fact that there was an agreement reached for a stipulation. So that's where I am. I can't go lower than a stipulation because that was part of the agreement. As part of my agreeing to accept the stipulation to begin with.
And I would add here, the reason why I emphasize restitution hearings are not the place to challenge the factual allegations of the case, and is because, there's no rules of evidence. Hearsay is allowed. It's not presumed that the state's going to be required to bring in all of its witnesses and prove up the case. When a person enters a plea to theft of over $100,000, the state doesn't have to prove that all the items that were needed to prove the $100,000 were actually stolen. To the extent that Mr. Stroud is arguing today, she didn't steal Krugerrands because they didn't exist. Therefore, she didn't even do theft of over $100,000. I think the court should disregard that. Thank you.
Well, they may or may not have existed, but they don't exist from Mr. Otto's standpoint in 2024, which falls back to 2028 or 2018. So that's the argument, but I already have other things that I have to consider. Any last words, Mr. Stroud?
No.
Any last words, Mr. Schmidt?
The restitution argument made by the state was never, you need to believe only Bob Otto. There's a reason Timothy Frey testified. Everything the court relies upon for finding any restitution on this requires finding Timothy Frey credible, reliable, and believable. The state thinks he was. If the court does, then it doesn't matter what was on one exhibit versus another.
Oh, it does. It does in all the things, because I do have to look at credibility of everyone who testifies at a restitution hearing. I can believe he is credible on one thing, but not credible in another. I can believe that he is stronger and believable in one aspect, but not in another. As long as I make sure that my words are communicated and they're communicated thoroughly in my order, that's all I need. I don't need to say, I believe him wholeheartedly, he wins 1000%, or I believe Miss Honeycutt wholeheartedly, she wins 1000%. Credibility is not a cut and dry kind of deal. So I have all the information that I need to make a decision. I do have my ample notes to rely upon and all of the arguments. I will get something out relatively shortly. The court, I always say this, Mr. Stroud, the court has 90 days in order to get out a decision. I am far faster than that. It would be 2, maybe 3 at the very most weeks that I have ever taken my time. Rank. The state doesn't appear, the state is not required to appear. This is a fail to pay case. Numerous warrants have been issued in this matter. This is a 2017 case. Mr. Frank pled guilty and was placed on probation on August 17, 2017. He was ordered to do certain things, ordered to pay court costs and fees in the amount of $443. The court ordered money to be paid towards that. and it hasn't been. He got a warrant in 18. He said he would pay. He didn't. He got a warrant in 19, said he would pay. He didn't. Another warrant in 19, said he'd pay. He didn't. And that's just 2019. And I'm not going to go through all of the years and do all of the things, Mr. Frank, because quite frankly, I don't want to. And it would take too much of my time and too much of my voice. I did waive a lot of the fines and fees, honestly, because I just don't want to deal with you anymore, Mr. Frank. Why haven't you paid the $200 that I was mandated and ordered by the Court of Appeals to order for a DNA surcharge? I waived the rest. Why couldn't you pay the $200? And so I waived the rest back in February of 2026. You did state after the hearing, when I said I would release you, you said that you were looking for a job. You said you had a girlfriend, and I think you were living with that girlfriend. I think the girlfriend was older than you. I'm going to guess 36 or 40. You called her old, but that is not an old age. Are you still with that girlfriend, Mr. Frank?
No, I broke up with her because she tried to shoot me up with meth while I was sleeping.
I mean, that's a good reason to break up with somebody. I'll give you that. So, Mr. Frank, I'm gonna guess you don't have a job.
I don't, but I also found out about my dad's house. I have to be off probation and out of jail to sell my dad's house.
That doesn't make sense. That's
That's
not
what-
correct.
That's what my brother Steve told me while I was in Polk County. He sent me a letter in.
Oh, that's because your brother wants you to do all of those things, all right? That's
Yeah,
what your
that's what-
brother wants. The
that's
law
what he
doesn't
said.
care.
That's what they said. That's what he said was in the will per what my dad put in there because I was the one taking care of him.
Well, then that's your dad's will and your dad's thing. But does he know you?
Who, my brother?
Your dad.
My dad, he's dead.
I know,
But
but
yeah,
did he,
okay.
he obviously knew you, so he put that in. He wanted to have you do better. He wanted you to stay out of trouble. He wanted you to stop committing crimes. He wanted you to not be on probation. He wanted you to not do drugs. He wanted you to get a job. That's why he put that in the will. And honestly, again, I don't care. I don't care about the house. I don't care about those things. You needed to get a job. You needed to do something, and I need $200. So how am I going to get $200, Mr. Frank? Because again, I waived a lot because it originally was, I think, up to $700 around there. It was $688.50. I waived all but $200, Mr. Frank, all but $200. How am I going to get that money that I can't waive, that the Supreme Court has ordered that I shall and must order with each conviction, and it's not waivable? How am I going to get the money?
I don't have any way to pay it.
Well, I don't have any other way to go about this. What I'm going to do is I'm going to order that you must sit. Well, how long have you been in custody?
I've been locked up since February 11th. I got
Not
revocated.
with me.
Well, so Monday of the 6th.
Monday of the 6th. And so, do you see why your dad put that in his will? Do you understand that? He's afraid you're going to dissolve and thrift away all that he worked hard to earn and to buy a home. Why were you in custody in someone else's care for 7 months?
Because I got revocated.
All
on
right.
probation for the charge when you guys picked me up in September of last year, you made me miss court and Polk. So
I
closed
made
that.
you miss court.
Well, no,
I
I'm not
made
saying
you miss court. Maybe your actions and conduct made you miss court, Mr. Frank. I did nothing. Neither did the law enforcement officers. Neither did the state. We did nothing. You did all the things, correct?
Yep, whatever.
Okay, yep, whatever. So you were revoked off of probation in Polk County?
Yep,
You have open charges anywhere?
nope. I'm pretty
Well, I
much
guess-
done with Wisconsin.
Excellent.
I have treatment lined up at the Burke House or Burkwood House when I get out.
Excellent. Court is going to order 60 days of jail, finding you in contempt yet again for failing to pay your fines and fees. I'm ordering 60 days of jail starting July 6th, when you were picked up from our ill-gotten silly actions of picking you up on the warrant. 60 days. And then I'm going to order, once you are released from custody, if you do not pay the $200 by, I'm gonna give you, so July, August, September. I'm gonna give you until December 15th to pay $200. If you fail to pay $200, the court will issue a warrant against you. You always owe this money, and the court, you could sit up to 6 months in jail. Do you understand, Mr. Frank?
Yep.
December 15th, $200. If by some chance you can beg, borrow, or plead for $200 from any friend, family member, or significant other, then you can bail out early. Once you pay, so it's 60 days or pay and you can be released. Otherwise, it's 60 days jail. And then once you're released, full payment of $200 by December 15th. Again, if you don't pay by December 15th, another warrant will be issued and we will be right back where we are here today. Do you understand?
Yep.
Because again, this is going way back from 2017 when you were convicted and the court did $443 in fines and fees, then other fines and fees were added. It increased to $688.50 in February of 2026 here. The court did waive everything but the DNA surcharge. And still no payment, not one payment since 2017. All right,
Honestly,
thank you.
Can I ask you a question?
One
How come
question,
how come you guys don't send anything to collections in this county?
because I like to collect. Deputy Carroll, please come forward, raise your right hand, you'll be sworn in, then come have a seat at the witness stand.
Do you swear that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
For the record, Deputy Carroll was hired to be the court security office on July 1st is when he started. He is a witness in this matter and this case. I will tell you, and I'm sure Deputy Carroll will confirm, that I've called him out on things, and just because he is an officer and now he's in the court security officer, I don't find his testimony to be more believable than any other testimony than if you were to testify, Mr. Wessels. It is based on a credibility. I just wanted you to be aware of that. He's new to here, so I don't even know much about him. But Mr. Felisky, you're aware that he is the court security officer. I just wanted to make that on the record so that you can talk to your client and just let me know.
Of course, Your Honor. Thank you.
Is it all good?
Yeah, I mean. Yep, we don't have an objection, Your Honor.
All right, so you may proceed.
Can you state your name, spelling your first and last name for the record?
My name is Jeff Carroll, JEFF CARROLL.
And what do you do for a living?
I'm a sheriff's deputy for the Burnett County Sheriff's Department
How long have you been a sheriff's deputy for the Burnett County Sheriff's Department?
since December of 2023.
Do you know a person named Bailey Mangan?
I do.
Who is that?
He's also a sheriff's deputy for the Burnett County Sheriff's Department.
Have you worked with him?
I have,
Do you know his work to be trustworthy and reliable?
yes,
Have you reviewed his work as it related to an incident on September 10th, 2024?
yes,
Specifically related to a controlled buy into someone allegedly named Travis Wessels.
yes.
What did Deputy Mangan do that day in regards to that controlled buy?
Deputy Mangan had met with an informant who advised he was arranged to purchase methamphetamine from Mr. Wessels at a predetermined location at around 6 p.m.
And did he meet with the CI there?
He did meet with a CI.
What did he do next?
He had searched the CI and their passenger of the vehicle. They searched the vehicle and did not locate any contraband items.
And what did he do after that?
After that, they provided the CI with 2 recording devices and followed the CI to the predetermined location, the laundromat and siren.
Did he observe anything of police interest at the laundromat and siren?
Yes.
What did he see?
Deputy Mangan observed Mr. Wessels arrive in a black Ford Ranger. He observed Mr. Wessels meet with the CI, going into a vehicle together, and then leaving.
What happened next?
After that, the CI had left from the laundromat to another predetermined location, which was observed by Deputy Mangan, met with the CI, and had searched them in the vehicle. Did not locate any contraband items until the CI had informed him. They had exchanged $240 for a flashlight, which contained approximately 1.97 grams of methamphetamine.
Can I ask, is that a literal flashlight or is that a new term for narcotics?
The report indicated it was a flashlight. I believe it was a literal flashlight.
Okay, thank you.
How did Deputy Mangan know it was methamphetamine?
He had field tested the substance and it field tested positive for the presence of methamphetamine.
What did the CI add anything else onto that explanation?
The CI advised he had given Mr. Wessels $240 and in return he was given a flashlight containing methamphetamine.
Okay. The laundromat and siren, is that in Burnett County?
Yes,
Did Deputy Mangan see the individual identified as Travis Wessels?
yes,
And prior to today, did he identify an image as depicting Travis Wessels to you?
yes, he did.
Do you see the person from that image in court here today?
Yes, I do.
Could you state where they are and what they're wearing?
Mr. Wessels is sitting next to defense counsel wearing a red t-shirt and glasses.
Let the record reflect that Deputy Carroll has identified Mr. Wessels.
I have no other questions.
All right, Mr. Belisky.
Thank you, Your Honor. Deputy Carroll, good morning.
Morning.
Deputy, you were not a direct part of this operation, correct?
No, I was not the investigating deputy, nor was I an assisting deputy in this case.
So you were not personally present during this incident,
That is correct.
and you did not personally observe any of the events which occurred as part of this incident.
That is also correct.
And you did not personally observe or speak to any of the parties during this incident, correct?
That is also correct.
Thank you. Deputy Carroll, your testimony here relies in part on the report drafted by Deputy Bailey Mangan, correct?
Yes,
And Deputy Mangan made a positive identification of Mr. Wessels at the scene, correct?
yes,
And that identification was made based on prior police contacts?
I can't recall what the criminal complaint states.
Thank you. I have no further questions.
Can you redirect?
No.
You may step down. Thank you. Any further witnesses?
No witnesses, though I'd ask the court to take judicial notice of the bond in Polk County 24 CF 204. This is an old case and that's an old bond, but the bond shows that the case was still open when this offense occurred on the date testified to.
Pulling up the case now. Court pulled up Polk County case number 24 CF 204, State of Wisconsin versus Travis Jeffrey Leonard Wessels. Court will look at the bond. The bond reflects not to possess or consume controlled substances without a prescription and only in the amount and frequency as prescribed, not to possess or use drugs without a prescription or drug paraphernalia, subject to testing to determine compliance upon reasonable suspicion or at the court's directive, no use or possession of any synthetic urine or masking agents. The court will also note that bond went into effect May 20th, 2024. This matter resolved on February 24th, 2025. This incident was the result of something in September 10th, 2024. Therefore, the bond was in effect. I will take judicial notice. Mr. Feliski, do you have any witnesses?
No, Your Honor.
Mr. Feliski, based on the testimony that you've heard and those things, do you wish to make an argument or just stand mute here today?
Your Honor, I object to the bind over, otherwise I
Well,
stand mute.
I have to ask this, unless you're going to argue more, but you.
No, Your Honor.
Other than you object.
I object, but I stand mute otherwise.
Okay, no, that's fine. Okay, I appreciate the objection, and it is noted. Mr. Wessels, I don't know your criminal history. I don't know anything about you. I quite honestly think this is the first case you've been in front of me, but I can't guarantee that. But you just don't look familiar and nothing's clicking with any facts. So I don't know anything about you. And so that means I don't know your criminal history, and I don't know if you've been through a preliminary hearing before. If you haven't, I will tell you some things about it. If you have, I'm just giving you information you should have been provided before. At a preliminary hearing, the bond is on this, or the burden is on the state to prove a felony was probably committed by you in Burnett County. And the court must view all evidence in what's called the light most favorable to the state. So if there's any question, it goes to the state's credit, okay? So it's kind of like a little scale like this. And the court can't judge whether or not, based upon the facts that have been elicited today or that are in the criminal complaint, whether or not these are the correct charges, or whether or not there's any defenses or anything of that nature. For this hearing, it simply is to find, did a felony, any felony, probably occur and was probably committed by you in Burnett, all right? So it's a very low burden. So based upon the testimony, and hearsay is admissible, that means that anybody can testify off of the criminal complaint. It doesn't have to be that specific officer that was present at the scene. Again, I'm just giving you that information. Your attorney has probably already talked to you about these things. But based upon that, the court will find that there is probable cause to bind over. So I will define a felony was probably committed and probably committed by Mr. Wessels. So I do find the probable cause information, Mr. Schmidt.
I filed the information. It mirrors the criminal complaint.
Would you like to proceed with an arraignment or set it for another date, Mr. Feliski?
Your Honor, we'll proceed with the arraignment today. As the information mirrors the complaint, I trust that Mr. Wessels understands the charges here and the maximum penalties. We'll waive any additional reading and all counts enter in pleas of not guilty.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial, and you would be entitled to a speedy trial should you request one. What I'm going to do right now is get a date for a status conference. Oh, but I opened the wrong thing. I have you coming back September 10th at 9:30. Does that work, Mr. Feliski? September 10th at 9:30?
That will work, Your Honor.
All right, you can come and get your notice and you're free to leave. Do you still have the same address of Butternut Avenue? Okay, so I was gonna say 2 years are hard.
33-year-old, yeah, he's He's a full one.
All right, we will go on the record in the matter 26 CF 78, State of Wisconsin versus Dustin Hanson. The state appears through District Attorney Kevin Schmidt in person. Mr. Hanson appears in person with his counsel, who is appearing by video conferencing. Stephen Ripple. We're set today in this matter for preliminary hearing. However, it is a waiver, I've been told. Is that correct?
It is. Yes, Your Honor.
And did you come from Monticello today?
I came from North Branch today.
Okay, so it's still a far drive.
Yeah.
I know it doesn't mean anything right now, but
Right.
had I known, I would have granted you the ability, had I known as a waiver, I would have granted you the ability to appear by Zoom.
Oh,
So
okay.
just like next time, and at the next hearing, which is probably going to be a status, and it's going to be probably a 5-minute thing, I'm okay if you want to appear by
Oh,
Zoom.
that would be great, Your Honor.
Okay.
Thank you.
All right. Okay, so your attorney went over with you what it is to have a preliminary hearing, correct?
Correct.
And he went over with you that the burden is on the state to prove a felony was probably committed by you, correct?
Correct.
And did he go over with you that by waiving your right to a preliminary hearing, it means, at least for this hearing, you understand and believe that the state can meet this burden?
Yes, Your Honor.
Do you understand at a preliminary hearing, your attorney would be able to ask questions of state's witnesses, call witnesses to testify for you?
Yes, Your Honor.
He'd be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses, but you're giving up that right today.
I am, Your Honor.
Do you understand at a preliminary hearing that if the state does not meet its burden, I could either amend the charges to a misdemeanor or dismiss them altogether? Do you understand you're giving up that right today?
Yes, I do, Your Honor.
Do you understand that once you give up the right, it is forever and you cannot get it back?
Yes, I do, Your Honor.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No, they haven't, Your
They're
Honor.
doing so freely you're doing so freely, intelligently, and voluntarily.
Yes, I am, Your Honor.
I will find that you are competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and bind the matter over. Information, Mr. Schmidt.
I filed the information. It mirrors the criminal complaint.
Mr. Ripple, would you like to proceed with an arraignment here today or set it for another date?
I'll enter a plea of not guilty and waive formal reading of the information.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. You're still on Red Rock Lane.
Correct.
Telephone ends in 1920.
Correct.
And may we send you text messages if we already are not doing so?
Yes, you are, and you can continue.
Thank you. Okay, now the next date is going to be what's called a status. Again, probably just a 5-minute or less hearing. Mr. Ripple, can you do by Zoom a status 9:15 on September 10th?
Yes, that works for
Or
me.
9:45?
9:15 works.
All right, 9:15, September 10th. Mr. Hanson, again, I'm giving you the authorization to appear by video conferencing. If for some reason you think you can't figure it out if you haven't already done it, or it's a little bit trickier, bad service, you can call in because that'll be fine. But I am going to give you the warning that if you do video or you call in and it gets the bad service, like you're cutting in and out, that's on you, not on me. All right, so I will find that as a non-appearance. Okay, so just make sure you have all your services working.
I understand.
Okay, come get your notice and you're free to go.
Thank you.
Thank you. We are
Thank
adjourned.
you.
Keep that. 'Cause it's-
In the case file here as document number 14.
All right, thank you, Mr. Flisky. Mr. Belial, I have in front of me the electronic document number 14, which is a waiver of right to preliminary hearing. Did your attorney go over that document with you thoroughly?
Yes,
And do you understand it completely?
yes,
And he explained everything to you word for word?
yes,
And if you didn't understand something, you ask him to explain it to you until you did?
yes,
So you're telling the court you fully understand what it means to waive a preliminary hearing?
yes, Your Honor.
Do you understand, or is that your signature on the bottom of the document? Did you
Yes.
sign it?
Yeah.
And do you understand that once you give up the right, it's forever and you can't get it back?
Yes.
Has anyone made any threats or any promises outside of an offer from the state for you to waive your right to a preliminary hearing?
Yes.
Did they threatened you?
No.
Did they promise you anything?
No.
The only thing that was somewhat of a promise was the offer presented, correct?
Yes.
And so are you entering or are you waiving your right to a preliminary hearing freely and intelligently? That means you're telling me you fully understand what you're doing here today?
Yeah.
And voluntarily?
Yeah.
I'm going to find that based upon this information and as it relates to the preliminary hearing matter only, and the fact that Mr. Felisky thoroughly went over with Mr. Belial what a preliminary hearing is and ensured that he understood what a preliminary hearing is and what it means to waive a preliminary hearing, I will find based upon those points that Mr. Belial is competent to waive his right to a preliminary hearing. The court will find probable cause and bind the matter over. Information, Mr. Schmidt.
I filed the information. It mirrors the criminal complaint.
Proceed with an arraignment or set it for another date.
Your Honor, I'm comfortable proceeding with the arraignment here today. As the information mirrors the complaint, I trust that Mr. Belial understands the charges here and the maximum penalties. We will waive any formal reading and to all counts enter in pleas of not guilty.
Not guilty pleas will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one.
Yes.
Okay, now let's get another date for you.
Your Honor, if I may, this matter has reached a resolution. Mr. Belial has agreed to a deferred judgment of conviction as part of this case. So if we could set the next date and time, the next available date, I should say, for a plea and sentencing.
The Teskey case at this point is a go. August 6th and 7th, I believe has reached a resolution. I have not yet taken a plea and it's just been stated it most likely will resolve. If you feel comfortable setting August 6th, knowing that it may not be able to occur if the matter doesn't resolve, we can set it for August 6th because otherwise we're looking at mid to late September.
I see, Your Honor. I suppose in that case, then August 6th will work.
How about 10 o'clock on August 6th?
That will work.
And I will let you know that I will know if it is going or not going for sure. July 22nd at 2:30 is the hearing, okay?
Would it be possible for it to be 10:30 instead of 10?
Did you double book a jury trial?
No, but if the jury trial doesn't go, I'd like to speak to public safety that day. They want to speak to me about a proposed ordinance I made.
I want to as well. So I will put that on my calendar as well if that doesn't go. So why don't we just say 11?
That will work.
All right, 11 o'clock. Must be Jacob Pardon outside. I can only see his head. Oh, he's still spinning.
Did you issue a warrant for Jacob Pardon with family something?
I did, but I quashed it. Yeah.
Okay, I was just about to run because I thought I remembered that.
There was, but he begged and pleaded for another day. So sometimes I can be lenient. Yeah. He's still spinning. Now he's off. If we get him back. I am very clear and I do tell them that if technology doesn't work, that's on you, not on me. Mr. Bruce, can you hear me?
I will turn my camera 29 check on Jacob Pardon.
Can you hear me, Mr. Bruce? I can't hear or see you. Motorola? Motorola. Who did I let in with the phone? If it's not Mr. Bruce. It's Mr. Bruce. Mr. Bruce, I'm asking you to unmute. There should be a button. There, can you hear me?
Can you hear me?
All right, now just don't walk, just stand and hopefully we can hear you. It looks like you have bad service, so you may need to just shut your camera off because I need to hear you more than I need to see you, okay?
Okay. All right, let me try and figure this out. I don't know how to turn the camera off.
I hit it. There you go. All right.
All right.
We will go on the record in the matter 24 CT 105, State of Wisconsin versus Daniel Bruce. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Bruce by video conferencing capability with approval of the court. The court set this as a quick turnaround because Mr. Bruce was going to go to the DMV and was going to pay his fee and was hopefully going to have his license by today. Mr. Bruce, update me. Did you do all of those things?
I did. I took the tests. I passed both tests, and I also spoke to the guy, and he said that I have to do these two things first, and that only the court can exempt these 3 vehicles that I still have registered to my name in order to get the interlock device.
All right. So that is just a quick form that you fill out, and you will need to bring it here to court. And I sign it the day that I get it in my hand. And so then that will waive those vehicles. And then you can get your interlock device put on. I'm going to tell you, I'm not going to give you a lot of time to do this because the case is 553 days old.
Yeah. I understand.
So what I'm going to do, lucky for you, I'm pretty booked the next couple of weeks. But I am going to put you in August 5th at 9:30. August 5th at 9:30, okay?
Okay.
If you have your license, because you've done all of those things before that date, you can fax or email or drop in person a copy of your driver's license to the district attorney's office. Then the matter will be dismissed, okay?
Sounds good.
But if you come back on August 5th and you still haven't done the paperwork to have those vehicles removed so you can get your ignition interlock device, and you still don't have your interlock device, I'm going to be a little frustrated, okay?
I understand.
All right, so August 5th, and if all of that's done and you've, again, given your copy of your driver's license to the state, you do not need to appear. So I'll see you then, okay?
All right. Thank you.
Thank you. We
Bye-bye.
are adjourned. All right, so I don't think we can go early on pardon because I believe there's victims, correct?
Yes.
We'll go on the record in the matter 26 CM 52, State of Wisconsin versus Jacob Pardun. The state appears through District Attorney Kevin Schmidt in person. Mr. Pardun appears in person without counsel. We are in victims' rights compliance.
Yes, Your Honor.
All right. So, Mr. Pardun, you failed to make your last court hearing. The court issued a warrant with certain dollar amount bail. However, then the next day or something of that nature, you did write a letter to the court indicating that you just simply thought it was a different date and you didn't know you missed court. Is that correct?
Yes.
And I did allow the clerks to quash the warrant for a hearing today. You're not retaining Mr. Zuber?
No, I'm not.
You're going to represent yourself?
Yes.
Okay. Now, Mr. Schmidt, can you please recite the offer again for Mr. Pardon, since he is representing himself?
Ordinance DC for costs.
Okay,
Which I think is 114.50.
but isn't there restitution?
No.
But the
Victim
rest-
said that he fixed the door.
Okay, so the dispositional supplement is not correct. Okay. So an ordinance for cost?
Yes.
Alrighty. Okay, so do you wish to accept that offer?
Yes.
All right, so as to count 2, disorderly conduct, formal motion to amend,
So made.
granted, how do you wish to plead?
Not guilty.
Not
Or-
guilty, it's
or-
either guilty or no contest.
No contest.
Okay, the court will accept your plea of no contest. I will assess $330.50. When can you have that paid?
Today.
Excellent, thank you, because then you get me off your back, you don't have to worry about it. So go and get that paid when we're done here today. The other matter is dismissed and read in. We are good to go. Thank you, Mr. Pardon.
Thank you.
Hey, the lady, on your way.
Will do.
Thank you. That was,
The defendant thought one mistake was about to destroy everything he had worked for. But then the judge did something nobody in the courtroom expected. It started like hundreds of other traffic cases. The defendant stood before the court facing a charge of driving with a suspended license. He admitted he was only weeks away from getting his driver's license back after working hard to satisfy the state's requirements. One conviction, one wrong decision could have delayed that progress all over again. The judge listened carefully. Instead of rushing through the case, he asked questions. Where do you work? How long have you been employed? What still needs to be done before your license can be restored? The defendant explained that he worked in healthcare and had spent years trying to rebuild his life after caring for his grandmother during her illness. He wasn't making excuses. He was simply asking for a chance to keep moving forward. That's when the hearing took an unexpected turn. The judge turned to the prosecutor and court staff. Rather than allowing the original charge to stand, they discussed whether it could legally be amended to a lesser offense that wouldn't create additional sanctions with the Secretary of State. Moments later, the judge looked back at the defendant and said the charge would be changed. Then he added, "She just did you a solid. That's going to help you." The courtroom immediately relaxed. The defendant realized he had just been given an opportunity many people never receive. But the judge made one thing absolutely clear. This wasn't a free pass. He still imposed fines and ordered the defendant to complete the court work program instead of serving jail time. Then he offered one final incentive. If the defendant returned with a valid driver's license within 60 days, the judge would consider reducing the financial burden. It wasn't about punishment. It was about rewarding someone who was genuinely trying to get back on the right path. Before ending the hearing, the judge wished him good luck and reminded him that the opportunity was now in his hands. One decision had kept his future alive. The only question left was whether he would make the most of it. Now, the question is, do you think judges should have the flexibility to help defendants who are clearly trying to rebuild their lives? Or should every traffic offense be punished the same way, regardless of the circumstances? If you enjoy real courtroom stories and unforgettable judge moments, don't forget to like, subscribe, and turn on notifications for more real court cases every week.